Yeah, morning, everybody. But I thought maybe start with just an iconography that lots of us are familiar with. That's you all heard of how if you throw a frog in boiling water, it jumps out, and how if you throw it in normal room temperature water, it stays in. And as you gently boil up the water, you increase the temperature. The frog continues to adjust, and ultimately the water begins to boil. It still doesn't jump out, and the frog ends up dying. Um, and and essentially that is what is happening with the legal system. We have been adjusting over a period of time. There's a crying need for reform because otherwise we'll end up like the dead frog. So that was what this iconography was. There are a few sides that so if you look at 2012 conviction rate, these are prosecutions brought in court and prosecution managing to successfully convict. I'm not even talking about complaints made and it doesn't go to prosecution. That is 38%. That's the success rate of getting somebody done in 2012. It went up to 46%. I think there's a bit of an overlap on the slide, but it goes up to about 50 odd percent. Now, 50% as conviction rate might sound not so bad, but if you look at the next slide, a lot of this data we have got from the public space. You look at crime against women, it is somewhere in the region of 15% conviction. You look at murders, it is somewhere in the sort of 20%, 25% region. Serious hurt is somewhere in the 20-25% region. Burglary is in the 20-25. What pulls up our statistics is convictions on motor vehicle accidents, which is the dot on top. But overall, we are sort of hovering around a 46.2% conviction in, if you look at the period 2014 to 2016. This becomes even more stark when you look at rape cases in particular, because that's always been a bother. It hogs the news headlines when it comes to it. You look at number of convictions at 3.01%. So that's all that we have been able to do, which essentially means that rapists have a free run in our society. And that simply cannot be allowed to stand. Now let's compare this. So if you look at, let's say, give India the benefit of the doubt, 50% is the conviction rate. Look at Japan. The cases that they bring to court, 99.4%. Israel, 93. China, 99. Russia, some 90-some percent. US, 93. In Britain, there are different kinds of courts, but 80-84%. Now, that means that there is a lot of headroom for us to improve our ability to convict. Now, conviction requires, at least in the criminal process, it requires a combination of how police and investigation works, which would come under the category of governance reforms and not really covered by this. But there would also be the element of how prosecution or prosecuting authorities or prosecutors work. How do they get appointed? How do they collaborate at the time of investigation? That will sort of pull up the conviction rate. But those are the kind of things that we need to sort of overall deal with. When we look at what is going wrong with our justice system, and so very often I've had these debates with people where I say that one of the most critical reforms that India needs to do is in the legal system or the legal enforcement space. And most people don't seem to have a lot of interest. But let's look at what are some of the consequences. So when we look at criminal trials, because conviction rates are so low, suddenly imprisonment in the course of trial, when people are arrested and they are otherwise entitled to bail, apparently courts don't give them bail, because that seems to be how we are moving toward. That's our new enforcement system, is that just deny people bail, because ultimately we know that these guys are going to get acquitted. Now, a criminal justice system cannot function on this basis. If you look at the sense of amongst the population, I mean, law-abiding citizens are generally perceived to be fools or idiots. There is a sense of jingoism amongst violators that, look, I've done this, I've not paid taxes, I've violated so-and-so law. And that seems to be gaining acceptable in our society. So there is increasingly the sense, and more so when you come to entrepreneurship, that if you want to be an entrepreneur, there are going to be some corners that you necessarily need to cut. And if you do not cut, if you do not violate the law, there is absolutely no way that you can actually make a successful business out of it. So that is our problem, is that we talk about economic growth, but our entire sense for economic growth is you do need to cut corners, because without doing that, you actually cannot make successful business. And that is a massive failing just in our legal system. It's not just that. Now, there have been instances, and I won't get into specifics, but there have been instances where I've known of people who require to do some compliances. They will say, I will not do the compliance because the cost of not complying, or the cost of breaching a contract, going through a court case, and at the end of the day, paying damages or paying penalties or paying interest, is actually lesser than if I were to comply today and pay up today. So if I were to put in an environmental protection plant, or if I am to comply with the contract, I actually in financial terms end up being a loser. So there is a compliance cost arbitrage. So as an entrepreneur, you start thinking in our current environment, you start thinking that, all right, I'm actually better served in business when I break the law. There is what a lot of us sense is the diminishing integrity in society, where we end up saying that, look, everybody lies to you, nobody is being truthful, and that section of the population is increasing. So our distrust within society is growing. What this does, it, regardless of who you elect to govern the country, governance becomes very difficult, and that results in a loss of confidence in democracy. So you've got to think whether we like democracy, we don't like, because increasingly you will now start moving to saying democracy, all right, we like our freedoms and our rights, but it is not working from a governance perspective. When we look at the political enterprise, now again, you have the notion of Sam, Dam, Dand, Bhed. Now that has become acceptable. Why should it be acceptable? Is that the manner in which our political enterprise ought to be run? And if that is how it is to be run, then it is Jungle Raj, then we might as well pick any system of governance. The fact is that this has become acceptable because it is impossible to actually function without Sam, Dand, Bhed in the political system. So it has now become a necessity, and that is the feeling of our legal system and our legal culture. Then you, of course, have in the media space, you have fake news, paid news, partisan journalism, and all this is on account of this. The legal system is actually not able to put pressure on all these negative elements. So really, what is it that is required to change? And very often our answer comes about in saying, let's change substantive law. So let's change big ticket laws, and that will bring us solutions. But the way I look at it is, so people talk about bring a new corruption legislation or bring a new economic fraud legislation. Now, the underlying legislation, which is the IPC or the Prevention of Corruption Act, already has provisions which you actually, if you implement, you will not need a lot of the special legislation. But what we have is we are not able to implement. So our political reaction or our state's reaction is to just bring about a new set of laws. Forget about implementation. Now, in that new set of laws, what you have, say, for an economic legislation is, again, attach people's property, arrest them, but you're actually not able to successfully convict them at the end of the period. So you will see a lot of high-profile cases in the news. There are not so many convictions that you actually see. So people are sitting in jail without bail, their properties are getting attached, but nobody, it's not resulting in the end result that we want. So we are gravitating towards a situation where we say midway works well for us. So because we know that we want successfully convict, let's actually go with temporary attachments, make business and life difficult for individuals. And that is not working well for our economy. Now think of it in terms of solution, not in terms of substantive law, but solution in terms of speedy implementation. Think of exactly the same laws that we have. You do not need to bring any new law. Think that every law will get implemented in a 1 or 2 month period. You will find that the nation will transform. And that is my point when it comes to enforcement and what needs to change, because there are a bunch of things that culturally have come down. So we could put it to the British Raj and the manner in which the legal system was engineered over there. But then we have 70 years post-British Raj, and 70 years of independence. And lots of us, particularly the old timers, will tell you that the laws are much better implemented in the past than they are in the last 20 years. So the problem is not necessarily only attributable to the British Raj, it is also attributable to us as a society which is failing to implement quickly. Now, very often when we think of reform, we start looking for the perfect solution. And the reality is, in a real world, there is nothing called a perfect solution. So as long as you keep running behind a perfect solution, you will never get to a solution. You will never reform. So the way to look at this, because perfect justice is actually a mirage, is to say, how do I enhance the level of justice? Because that is more likely to be practically feasible than saying that I will reform only if I have a perfect solution. Otherwise, what I have is good enough. Because then that's actually a recipe for no reform. But the solution lies in two basic spaces. One is, how do you enhance speed? And there are some structural changes that are needed over there. The other is, how do you create an environment where the common man is in natural alignment with the whole set of laws. So he doesn't need to get educated. He doesn't need to be a scholar to understand what he can or cannot do, but it comes naturally to him. So that part, I would say, is an alignment of the legal system with the basic Indian mindset or the basic Indian instinct. Now, in this, I would, in bringing about speed and bringing about change, I would say one of the foremost is constitutional change, because there is some basic features that need to undergo a change. There is a reliance on technology that we need to do, so technological change, and there's a lot of discussion on technological change in the COVID times, where there are virtual courts, they talk about electronic courts, they talk about artificial intelligence, and we'll talk through some of those, because those have not come about only in the time of COVID. Those have existed for the last about 5-6 years, and they've been growing around in various parts of the world. There are some business laws that we need to change, and very few changes can actually bring about large impact. There are some other general changes that need to sort of come about. On the alignment with the Indian instinct, I put it into 3 brackets. One is, what would you change on the civil law side? What will you change on the criminal law side? And what are the cultural issues that come from the British style of implementation of the legal system that we need to also sort of relook at? So going from there, so when I think in terms of constitutional changes, one of the foremost one, and this is used in certain other countries, is to, at least in the higher judiciary, make judges for lifetime. This, when I say it is judges for lifetime, it is obviously subject to the ability to impeach these judges for improper conduct, but just make judges for life. So do not retire them at 62, do not retire them at 65, but let them go on until they are incapacitated, until they are unable to do their job. Now, what that does, it isolates a judge from any pressure that he may have for what shall I do post-retirement. That makes him more independent. Now, this independence is true independence because it comes regardless of who appoints you. So you may have a very powerful leader, you may have an Indira Gandhi, or you may have a Narendra Modi that appoints you, very powerful leaders. But as soon as you now are employed in this job for the rest of your life, you can now turn around and push back against them, because they can't do anything more to affect your career, either in terms of progression or in terms of pulling back. So it gives judges true independence. It then brings to the question here is that if you end up, if it is lifetime judges, then do you end up what happens if you end up appointing somebody who is suboptimal, who is not necessarily a good judge? Now, when you know that it's an appointment for lifetime, it then puts pressure on the appointing system to make sure that you can get as many good guys in there, because I may be of one political perspective at this point in time, but if I get a compromise candidate, so somebody who's buying into my political philosophy only because they want some advantage in professional career, they are likely to behave very differently once they get, because here you're looking at somebody who is sort of not a person of high integrity. If we appoint such people to courts and they become judges for lifetime, they end up being bullies. So there is this huge pressure that will build up once you have judges for lifetime, is to try and appoint as many decent guys as you can to the judiciary. We can take the US system where we have a parliamentary scrutiny of judges. So they are committees that sort of scrutinize judicial appointments. We can take the National Judicial Commission route, which is just, again, another specialist body that goes about appointing judges. The reason why our current collegium system, according to me, doesn't work is I essentially look at it from proof of the pudding lies in its eating. I look at the quality of the judges that happened before the collegium system and the quality of the judges after the collegium system. And I don't know any lawyer of any decent standing that will tell you that the quality of judges today under the collegium system are superior to the quality of the judges that were appointed earlier. So my sense is that the whole collegium idea is actually failed. Lots of us accept it, except you don't know what are you going to do in terms of substitute. But these are the kinds of things that you need to look at in terms of substitute, and it needs to go through fairly quickly. There is then the entire the distinction or the separation of constitutional authority and power. Is the judiciary stepping into the space of the executive? And this is not just a theoretical idea. The reason why this is relevant is that when an executive or when the government takes decisions, these administrative decisions, they are better informed. They have ways to gather information when they take those decisions, which judges don't have. So they gather information, they take these decisions. For every decision, there is a court that can exercise judicial review. But when a court, with whatever information gathers on account of people that are standing before it and arguing the cases, because they don't have too much ability to get information outside, they could very often come up with suboptimal results, and they are not subject to judicial review because they are in a jurisprudential sense, they stand at a higher plane when it comes to testing a certain administrative or statutory action. And so therefore there is a need really to bring back judges to doing more review than heading up or taking the lead with administrative issues. When you say that judges should go back to doing judicial review, it does not address one of the country's biggest concerns, is that governance is not working. So if I want a school, if I want reasonable decisions in administration, that is not happening because I can't just rely on the ability to vote once in 5 years to get people in the executive to do the right thing. So I need some form of intervention, because that's ultimately where our system has ended up, is that our governance system is very often not responsive to what the people need. The thought over here is to address that system, don't really clutter up the courts, create special tribunals that can be sort of quasi-judicial tribunals, that could be public interest litigation tribunals. And decisions in tribunals can always be subject to judicial review. These tribunals can be set up by appointing people just like you appoint superior court judges. So it could be the same system. And so therefore, as a common citizen, when you're dealing with an unresponsive executive, you should have recourse to some authority, but not necessarily judicial authority, because once the judicial authorities or the courts take wrong decisions, there's nothing to actually review it. The one other change, and this is sort of constitutional legal change, is to try and start limiting appeals to just one appeal. So from the lower courts, one appeal to the high court. From the high courts, maybe you take one appeal to the division benches. Is for the Supreme Court to essentially function as a court of statutory interpretation or constitutional interpretation, and therefore not actually get into appeals in substantive cases, but just to decide on issues of law. There are a few other points that I'm not getting into any great amount of detail. They're there in the presentation, but I thought the important one over here is performance review of judges. We have performance reviews at different levels. One of our great failings as a state is our executive or a bureaucracy is not sufficiently reviewed. But that is not sufficiently reviewed. Our judges have zero review. So there is a need to actually build. Now, judges It is also because we come from the mindset that we want independence of judiciary. The judges actually exercise sovereign power, and therefore you should allow them the flexibility and the freedom. But I think those are imperial ideas. I mean, when you look at the Indian system, every person, if you look back into Indian history, people who take decisions, their decisions are always subject to review. The public always looks at them, figures out what needs to be done. So there has to be a mechanism of reviewing judges, because you can't have this sort of I'm a sovereign, I'm exercising sovereign authority, and therefore my decision should not be subject to any review. That's sort of the constitutional changes. I get into technological changes. The fact that you should have mobile courts is something that has been discussed for a long time. Nothing has happened. So this is essentially like a van that moves around from one place to the other, so that litigants don't have to come to court, but courts can go to litigants. So that was the idea. And it's kind of time that we look at least for some kinds of cases, to look at this sort of solution. Because just coming to court is extremely expensive. Hiring a lawyer is extremely expensive. So you take justice to the people. The other one, and I think this is where there is going to be, so at the moment, our entire bar and bench are readjusting to virtual courts, or courts happening through systems as we are having this presentation. There's a series of adjustments that is happening, but once technology begins to improve, and I think over the next 1 year, as more electronic interface happens, technologies will improve. It is probably time that we sort of look at the option, or at least present people with the option of having their cases tried through virtual courts, because it could be much quicker. A virtual court doesn't require to go to one particular judge. A virtual court can result in your case from Delhi getting heard somewhere in Bangalore. So it creates sort of all kinds of efficiencies that we should be using. There's one other thought, and this essentially comes to the fact, and this is when as lawyers you appear in courts, you get the realization that all judges are not at the same level. Their understanding of the law, their sense of precedent is very, very different. And truly, you can't have a modern justice system which is so subjective to a judge's capability, one man's capability, or your lawyer's capabilities for that matter, because justice should be the same for everybody. And the practicality, if you have a technological solution that can take away this sort of the difference, or the arbitrage that is enjoyed on account of such difference, then we should deploy that technological ability. And one of them is to create some sort of a knowledge grid. So for judges to very easily sort of tap into, to pick up the phone, speak to somebody, you've got large BPO operations that are happening for various things. There can be some form of a large BPO that is set up, one or more BPOs that are set up that are also technologically linked, that can support the judges and the courts. So that's just creation of a knowledge grid. This can also bring about immediate sort of case law to the vision of the judges, so they will know exactly what has happened. So every time a new case law evolves, some regulation changes, they'll be up to speed on everything, because that knowledge they did not house in their own heads, but they can actually pick up a phone or send an email and get that knowledge through to themselves. I've got something over here that says create templatized pleadings. And this comes actually from my having worked in a large law firm and looked at a lot of international law firms' work. What I realize is that they have been able to somehow institutionalize capability. So you could have an average lawyer, because that lawyer works with a series of templates, that the average lawyer actually looks much better, because the product that lawyer delivers is far superior. And there's no reason why this cannot happen, including in a court system. So for example, let's take an example. You have a landlord-tenant case, which many of us have. Now, there are only so many variations to a landlord-tenant case that are possible, which in the last 70, 100 years, I would imagine India has experienced all of those. So you could actually create a template, something like a Dropbox, and I'll show visually what it might look like. A Dropbox system where people need not start writing the English language when they are doing pleadings, but you can actually click on buttons, pick which space you would fit in, and that could create your pleading in terms of if you're a landlord or if you're a tenant. Because, and for the few ones where it is not one of something that comes from the database from the past, you could have a special category where you can write down your special facts. But otherwise, you could have a drop-down format, because the drop-down format is really what will help you ultimately get to artificial intelligence. Because if everybody writes their pleadings in the manner that they do, because everybody's language skills are different, the way they present are different, it is impossible for a computer to work with those. So artificial intelligence and use of technology will actually grow when you templatize pleadings. One of the big advantage of templatizing pleadings is today, as I sort of alluded to in the context of judges earlier, is that lawyers have different skills with English. Lawyers have different skills with the law. But in the least, you can take out the arbitrage that certain lawyers will enjoy on the basis of their language skills. Because justice must be the same. It should not be dependent upon how well your lawyer can speak or the kind of expressions that he uses in court. It can't be that if I use lawyer A that I get justice and I use lawyer B that I don't get justice, because that was a burden that we had to carry because there was no alternate to it in the past. But today there is alternate in terms of technology. We don't have to carry that burden any further. And so therefore, templatizing pleadings and artificial intelligence, I've got something that says record and broadcast court proceedings, that just to bring transparency, because there are various behaviors that you actually encounter in court, which are much better off once they are in the open space. Those behaviors will go away. The questions around integrity of courts and all those would get cleared out, because once you're in the public space, there is lesser flexibility to act in a manner that may not be reflective of integrity. So this is kind of how a templatized system might work. And there are law firms around the world that have used systems such as this. So it's just boxes. You click one box, it opens up another set of boxes. You click that box, it gets you a third set of boxes. They're yes or no kind of answers. So in certain practice areas, for example, insolvency and bankruptcy has moved almost entirely to computers and to artificial intelligence. So this is how practices are run. There is no reason why a country like ours should not scale up the very same idea and bring it to the courts. So when you look at artificial intelligence, as I said, the only way to do it is to actually get into that sort of templatized fashion, because that's when the computer can analyze what works in which fashion. You minimize dependence on the skill of the judge, the temperament, the knowledge. So very often, a lot of us as lawyers experience this, is that a judge may be in a good mood, you will get one kind of justice. He's in a bad mood, you get another kind of justice. Now again, what sort of system is this? In the past, again, we had no option but to carry that handicap. But with technology, we have the ability to take away that handicap. And that is what we should do by using technology. China is not a very happy country to be using as an example, but there are some remarkable things that China has done with use of artificial intelligence. Now, again, is that for certain subjects like sale of goods, intellectual property disputes, trade disputes, e-commerce product liabilities. Now, all of these kinds of disputes, if you look at in India, you go and file a case, you find a lawyer, it will take you 3-4 years to get through a trial stage. These guys get from filing to conclusion done in 38 days. This is done by using artificial intelligence. So some of this is also done by using on a phone. It's on an app. So you can actually say, yes, no, this is the amount of claim, this is the kind of claim. The other side gets a right to actually respond to it. You have an outcome in 38 days. These are the kind of timelines that we should be looking at. Not 3 years brought down to 2 years. We should be looking at 4 years brought down to 6 months to 3 months. Because we are a large country. That is what will improve the level of justice. That is what will improve the level of compliance in our country. That is what will take our economy to new economic heights, because sanctity of contracts will be there. But moving on. So moving away from technology, now just to the business environment, and there are a few things that we can do to actually alter business environments, and these are not very big things. So for example, In our country, damages, if you breach a contract, damage is meant to be compensatory in nature. It is not compensatory, for example, in the US. So when you look at India, our inclination to breach the contract, and I was saying there is arbitrage in breaching a contract, is that in US there's a disincentive because you get hammered by a huge amount of damages and a huge amount of penalties. In India, the damages that get awarded against you is very small. So you take interest, you take damages, and you figure out actually, instead of complying, instead of fulfilling my obligations under a contract, I'm better off breaching it, because that money that I retain, it's like borrowing from a bank at a lower cost. And so that does not work, because as long as you have incentive to breach because the damage levels are low and it takes a very long time to get it, there will always be an incentive to breach. So we need to move away from that compensatory kind of damages. We need to award consequential penal damages or large damages. We then are a disincentive for breach. We also need to start avoiding costs on an actual basis. So what happens is that we do have the idea of cost, that if you use a lawyer, whatever fees that you pay to a lawyer, if you win the case, then the losing party must reimburse it. But the amount that is awarded as cost is tiny. It's 5,000, 10,000, 50,000, 1 lakh. Very often when you do cases, you will encounter that whatever kind of lawyer you use, the cost of using a lawyer is much more than that. So costs must get awarded on actual basis, because if I am a victim, then I must, in the least, when justice is delivered, be put in the same place or as close to a place as if the breach had not occurred. So at least you must try and put me back, which includes somebody else picking up lawyers' costs. There's a point on injunction and how injunction should be dealt with, but again, for a general audience, not. But from a business perspective, very important, because court injunction. So our court system is very, very slow for almost everything other than injunction. Now, what is an injunction? An injunction stops whatever is happening. So in other words, in common language, we call it a stay order. So our courts are terrific in stopping things from happening. Good things, bad things, we are great at stopping things. It's very difficult to get something done in our country. And so therefore, injunctions, while the law is fairly clear, you will find that the courts don't function clearly in terms of the established case law. And so maybe there is room to now start building rules. So bring it into statute and force courts to actually deal with those particular principles when they deal with stay orders, either when they're granting stay or not granting stay orders. There is then the issue of contingency fee for lawyers. Now, you will hear very often complaints saying that, oh, my lawyer is not interested, lawyers are causing delay. Now, the reason why lawyers are causing delay, I mean, there could be various other reasons, but clients would attribute them to saying that they are trying to extract greater fees from me. Lawyers will say that it's not that, there are various other reasons why there are delays, why we agree to adjournments. Now, an easy way to also deal with it, and this kind of fees exist now almost in various other parts of the developed world, is contingency fees. So a lawyer will get a basic fee, but when he succeeds, he gets a large fee. Now you build an incentive, a financial incentive for a lawyer to finish up his case very quickly. You will find that lawyers will actually start functioning much faster in a more efficient manner. What contingency fee does is also reduces upfront burden on clients. Now, a traditional argument has been, oh, lawyers will now abuse this ability when they deal with poor clients. So if I don't agree that people are poor or they don't understand their rights anymore in this country, now with a lot of information and a lot of, whether it is through television or it is through the internet, information is widely available. People are not as foolish as they were 50 years back. So it's harder to fool clients into something like this. But the upside of contingency fee is enormous, because the client doesn't need to pull out that money upfront in large amounts to actually get justice. Now, the other element of contingency fee, particularly when we look at the US, a large amount of development of the law, whether it is in environmental protection, in terms of employment, in terms of tortious claims, have essentially come about because lawyers have worked on contingency fees. So when you look at whether there's sexual harassment law, whether there's environmental protection law, almost all of it happens because there is contingency fee, because a small employee can't really afford big lawyers. So if we start hiring small lawyers, the corporation hires an expensive lawyer, and it's a very uneven battle. The only way to even that battle is to allow greater financial incentive for the person representing the small guy. And that can be achieved only if you actually take the contingency fee route. At one point, sort of, there's this whole push to say that let's go towards arbitration. I actually believe that commercial courts are better because there are integrity issues around arbitration. And it's not specific to me. In the US, this is how they look at it as well. US has arbitration, but they tend to prefer the court system because courts are open, arbitrations are private. If something wrong happens in court, you have an appeal. In arbitration, there is no appeal. At one time when arbitration was propagated, it was meant to be an informal sort of thing, not as expensive as litigation. But as most of us who do arbitration will now see that it is as expensive and is becoming as technical, if not more, and as difficult, if not more, as courts are. So really the original purpose with which arbitration started are not working. And they come with the downside of integrity issues and the inability to appeal if they are integrity issues. We then have that there are room for making a few big changes in law. And this will clean up the business environment. So one is the whistleblower legislation. Now, whistleblower legislation is not only about protection of the whistleblower, but say for in the US, they have an incentive. So if you blow a whistle on wrongdoings in a corporate entity and a financial penalty is recovered, the whistleblower gets 25 to 30% of the recoveries. Now, in India, at least my own experience has been a lot of promoter companies. Promoters will want various things done, and employees will say, I have no option but to actually carry out what the employer wants me to, because otherwise I'll be thrown out of a job. So it's a hard situation to be in. But if you provide that employee the option of saying, all right, if you are going to whistleblow, we will get to convict the employer, impose a large financial penalty, and you will get 25-30% of it. Immediately there will be internal resistance to doing wrongdoing. So employees who are prone to having greater levels of integrity will look at the option of being whistleblowers. It will bring down the cases of corporate fraud because the sort of the hand in glove that happens between management and the workforce will stop happening. At least there will be an option for it to stop happening if you have whistleblower legislation. It goes hand in hand with something called the witness protection program, which you'll see movies coming out of Hollywood which describe how witness protection programs work or plea bargaining works. Now, all this helps in getting speedy convictions against powerful individuals. Now, these may be powerful corporates, they might be powerful underworld, but if you can make the witness disappear, you can give him a completely new identity. Or if you can get an accomplice to do a plea bargaining or become an approver, you will get much faster convictions and closures to criminal cases. The last point over here is a propensity to lean today in terms of imprisonment. Now, again, what a lot of us have experienced is when you talk about corporate frauds, people are happy to go and sit in jail because the size of the frauds are massive. So I am happy to sit 5 years in jail because I can finance a fairly okay life when I'm in jail. And when I come out of jail, I have the wealth to enjoy. We need to, I would say, gravitate towards imposing heavier penalties rather than imprisonment. So make the guy poor. Make a Vijay Mallya or a Nirav Modi poor. Forget about imprisonment. If imprisonment happens, happens. But let imprisonment not be the primary goal that we look at them. Make them poor, because making them poor will create a disincentive for anybody else that tries tricks like that to become wealthy. Because it works better for them to spend a few years in jail, come out and enjoy the wealth. And that is again creating certain sort of anomalies in the manner in which our system works. So that was sort of essentially what I had in terms of change in substantive general issues, technological issues, business environment. This section is how do you align the laws with Indian instinct? And essentially so that compliance comes naturally to Indian citizens. You will also find, and this, there are going to be some hard points made over here because A lot of them would balk at just the very idea, but as we talk through them, you will begin to see a greater sense. Many of them will not accept these ideas immediately because our view of how the law must be implemented has been ingrained for the last 100, 150 years. So how do we sort of look out of that? How do we change basic, how do we move this in the direction of acceptability amongst the larger population? So the first one is to move, and I think there has been debate around this in the Indian system as well, is our courts are adversarial courts, and I'll explain what adversarial is, and they need to move towards inquisitorial system. Now, the English system is adversarial, the European system is inquisitorial. An adversarial system, what happens is the plaintiff or the prosecution, in a civil case, a plaintiff, in a criminal case, a prosecution, the entire burden of proving the case is on them. The defendant or the accused or the criminal can just sit back and enjoy life and poke holes in the other guy's case. Now that imbalance is a little less when it comes to civil cases and an extreme when it comes to criminal cases. Now that is not true, and so the judge acts as a bit of a neutral umpire, though our judges have slowly begun to try and determine facts, but they are a neutral umpire to the case, to the two different cases being presented to them. The question is, should you function as a neutral umpire, or should you be looking to do justice? So should you be in the quest of justice and not just act as a neutral umpire listening to the two arguments? So the European system is the courts actually try and find justice. And that sort of creates a greater equality in burden of proof. And I'll deal with it when it becomes starker when we talk about criminal prosecution. But it therefore, in civil cases also, it would require parties to bring all relevant facts to court. Because today what we have is plaintiff makes a case, respondent only has to say, I agree, I disagree for this reason. But I am under no obligation as defendant to actually bring out my entire case. So essentially, I just need to bring down the plaintiff case, and that creates the imbalance. And that balance needs to be corrected by moving in the direction of inquisitorial courts. We do have the idea of perjury, i.e. you go to court and you tell a lie. But anybody of any substance will tell you that one side is almost always telling a lie in court. In most cases, we don't have, while we have a law for perjury, we don't have perjury actions being initiated. So there is no pressure against lying. So you can very happily get to court. And again, there is a jingoism around it. Amongst lawyers, there's jingoism. Oh, I went and bluffed in a court. So this jingoism, now why should that jingoism exist in a system that is trying to deliver justice and fairness? And really, there should be a greater action in perjury situations. We then go to the next issue that I have, which is, it's again, in my mind, an imperial idea, is presumption of law. So the English came up with their sense of law. They realized that the Indian population, and this is not just in the context of India, the English did it in their own country as well, because there were the Normans that were rulers, and there were the Saxons and the Celts, which were other communities. They did it there, they did it here as well. You come and you say, this is the new set of laws. Now the community, you don't inform or educate the community. The community has its own sense of fairness and justice. So what you do is you say, there's a presumption that you guys know what the law is. And therefore, if you make a mistake, that is not a difference. You will face the brunt of the law. That probably needs to change, is that the whole presumption of knowledge of law, there must, one, be an obligation on state to make efforts to socialize law. And if you don't know the law, and if you can really prove that I don't know the law, you should be able to use it as a defense, which today is not available. Again, it's a matter of great debate. You can write, you can do research papers, and you can debate this to the end of the world. You can write books on this issue, but just a brief point, because we don't have as much time, so briefly made. Similar idea is of sovereign immunity. So we have a prime minister today saying, bureaucrats act fearlessly, even if you do a wrong, you will be protected. Now, that idea of sovereign immunity is not an Indian idea of sovereign immunity. And this is why, I mean, not an Indian idea. Sovereign immunity is not an Indian idea. We have many examples in our mythology, in our history, of people following the rule and still getting penalized for some reason. So they don't enjoy immunity. They don't have the ability to say, look, I did it in good faith. I did something in the belief that I'm doing the right thing, but if it worked badly, I'm not responsible. So let's take, I'll give you a few examples to sort of illustrate this. The most famous one that I would say is the beheading of Ganpati. Ganpati's mother told him that you stand outside, don't allow anybody come inside. So he was following a rule, but Shiva comes and beheads him. Similarly, you have the story of the four Sanata Kumars that visit Vaikunta and they're encountered by the gatekeepers, Jaya and Vijaya, who don't allow them in because they are not supposed to allow anybody inside at that time. They get cursed, they get born as Ravana, Kumbhakarna, Hiranyakashipu, etc., etc. My point is that, and there are various other examples. There is Dashratha shooting Shravan Kumar. Now, again, it's a mistake. They didn't intend to do wrong. He thought that he was legitimately killing an animal. But you have to bear the consequence. Even if you are sovereign, even if you did it in good faith, even if you did not want to cause harm, you must bear the consequence. In our thought, you can seek a mitigation of consequence. So you can say, sorry, I did a wrong. So then somebody who's a Vishnu will come and say, okay, I can't reverse the curse, but I will come and kill you in the future. For a Ganpati, they will come and put an elephant head. So there are mitigation measures that our tradition has, but we do not have the concept of full sovereign immunity. None of the Indian devatas, none of the Indian rishis, none of the Indian kings have ever enjoyed the idea of sovereign immunity. This is an imperial idea and it is time to junk it. And I don't think a bureaucrat who performs things and gets it wrong should be entitled to a scot-free existence, or for that matter, a court. Now coming to criminal law system. Now we have adopted this sort of Anglo-Saxon idea that we don't want to, the state must not end up punishing an innocent, even if that means 100 criminals are loose. Now what that has happened, what's happening on account of that, and it's called the Blackstone principle. What's happening on account of that is we have hundreds of criminals running loose. And when it says you shall not convict an innocent, very often you will see, though that is the principle, there are a lot of poor people actually facing conviction, of poor people facing imprisonment and for long periods without bail. Who are the guys who take advantage of this? This is the wealthy and the powerful. So it is now trying to reverse it. The idea is not to say that it is acceptable to convict an innocent, but I think it should be completely unacceptable to let 100 people free, 100 criminals free, just because you're scared of punishing an innocent, because it's very hard to get out from punishing an innocent. And if you take the no sovereign immunity protection hand in hand, then really if you end up convicting, whether it is as prosecution, as investigators, or as courts, there must be a consequence to something like that. I spoke about inquisitorial courts. Again, in a criminal system, essentially our accused can sit quiet. In Europe, an accused cannot sit quiet. You have to actually make your case. And I have dealt with a few cases where white-collar crime situations, prosecution in Europe, prosecution in India, and it is unbelievable how the European lawyers are enthusiastic about wanting to prove why they are innocent, rather than our inclination to say, I don't have to prove I'm innocent, I just have to prove that the prosecution has not made out a good case. And I think that reversal of burden, if we want to increase the level of convictions, has to happen. We also have this sort of great inclination coming in the same vein of leaning in favor of accused rights as against victim rights, and I think there needs to be a reversal there. Again, contentious issue, right to deliver personal justice. And my sense is, I'll tell you what I think, and I'll then speak about it. My sense is that you go to a state authority, you go to the police station, it does not deliver you justice. You must then have, it must be a defense to say that I sought state protection, state did not deliver, I will then protect myself. Now, there is a right to defense under even existing law, but it doesn't work like this. It is not a defense to say, I went to the cops didn't respond. Our right to defense is sudden and immediate. So if it is sudden, I don't have the ability to go to the police station, then I can defend myself. I'm saying we need to gravitate from there because the police force is by and large dysfunctional. Our court system today is dysfunctional. That right must come back. Now, when we talk about the right to violence, inherently, you've had a citizen is meant to have a right to violence, which you surrender in favor of the state because the state exercises violence to give you protection. But when the state fails to do that, in jurisprudential sense, this right must come back to me. And that's the point that I would want to make. Where do you take that violence? I have a view which is slightly different from a non-pacifist, slightly aggressive view, saying that the British wanted to rule India and therefore outlawed the use of guns and weapons. And that, in sense, incapacitated Indians. It made us subservient. If we were not able to defend ourselves, the common man today is unable to defend himself. And maybe there's a need for a debate as to whether relook at this law. I'm not saying that, like in the US, you allow automatic weapons to be sold off of Walmart, but you must have a right to carry some form of basic weapon to defend yourself in the least. When it comes to theories of punishment, so that's the next point, is we have a situation where we have concurrent punishment. So if I'm committing robbery, there's also murder, there's also some other offense. So you sort of overlap trespass. These sentences overlap. Whereas in the US, they run in a cumulative fashion. So if I say it's parallel versus series, for those who sort of understand maths and physics, so it's not, you don't overlap these judgments. So somebody doesn't come out in the maximum period, but you have to finish one, then you do the next, then you do the next. That's a great deterrence. If you figure out that I'm going to be in prison for 200 years, it is different from saying I'll be in prison only for 7 years because I can get all these to overlap. But it, as again saying, it functions as a deterrence. It is more in the nature of retribution. The societies need to say that, all right, somebody is a criminal, you must hit back at criminals. And again, I come from a non-pacifist view, so I don't say, I'm not a big one for saying that be easy on criminals who are once found to be criminals. There's no need to be easy on them. There is then the tricky question, again, need for debate on police violence. So we have, all of us say that police should not be violent. But let's look at the cops' perspective. Cops will say, look, if I arrest somebody and if I sweetly ask him, have you done theft? Have you done murder? Nobody's going to admit it. I have no option but to beat up some people because that is how I get information out. When you look at Indian society, if you look at society by large, we will say, all right, we don't have a problem if you beat up a real criminal. Our problem is if you beat up innocent people to force them to say, I'm a criminal. But if you are going to beat up somebody who ultimately is a criminal, we don't have a problem. So the issue is really, how do you distinguish before somebody is found to be guilty? How do you say, this guy is a criminal, this guy is not a criminal, and how do you allow for violence to happen against that person? The problem is there's also, as I said, there's a practical problem of how do you do investigation and how do you do it quickly. And we have a challenge because of the lack of training that the cops have. There is the other element of encounter killings. So what stood out very starkly in my mind was the recent Hyderabad police encounter when a rape victim was involved. There was enormous amount of public support for the cops that they were seen as heroes who went and sort of shot dead 5 or 6 rapists. Because at the same time, we were dealing with the Nirbhaya situation, where again these guys had been convicted and the cases were dragging. One of them is actually running loose because he's been seen to be a juvenile. He was 1 month short of being an adult. So there is this imbalance. And when you see society actually finds greater acceptance, there's good public support. But every time the police commits violence, whether it is to find how the crime has been committed in the course of investigation, or is it to do sort of extrajudicial justice, they actually are committing a crime. The cops are committing a crime for which they must be prosecuted. But they have public sentiment support. So when you're a democracy, how should you act? Is democracy should a democracy give out laws that only the elite believe is a good law, or should the population want to believe it? And there is a balance to be struck there. That's why I say there's a need for a debate. But I would say there's enormous public support. I mean, in my mind, this also stood out in another instance. There was a senior police official and I won't name him, but a very well-known politician today who went to jail because they said that they killed a criminal, a known criminal, underworld don. Now the question was, these guys went to jail for long period for killing an underworld don, but all our Bollywood movies, the Amitabh Bachchans and Ajay Devgans, are busy shooting the criminals, not taking them through the prosecution process. And every time you see them taking somebody through prosecution, you feel that what an idiot this guy is to take them to prosecution, because it's quite clear that so-and-so is the criminal. Why don't they actually just shoot them? And there is applause in the movie halls when a cop would shoot. What I'm talking about is, how does the public look at it? If you say that you're a democratic country, should that elitist view prevail over the mass sentiment that exists in terms of how do we approach justice? And there is therefore, in my mind, a need to debate that. There is then, again, this is a slightly tricky issue, is that dignity of women. And I mentioned right in the early beginning, the sort of the conviction levels that you have with rape cases. Is that there are two basic issues that women encounter in our society, and I'm not getting into rape because I think rape is an outcome of a sick mind. There's something wrong with the person who actually goes and commits rape. But almost all men that I know will indulge in some activity that some women might find offensive. It might be just a way that you look at a woman. It might be the way you speak to a woman. There might be some women that are happy being looked at in that particular manner, but other will not be happy looking at. So normal people end up being in a certain situation. So if I were to look at it in outcome terms, you look at every woman who lives in Delhi, every time she goes out in fear. There is the fear that you will in some fashion get harassed, whether the way somebody looks at you, somebody touches at you. This is every single woman, regardless of which level of society that she comes out with. This ends up putting a great amount of pressure on women. Their freedom is naturally curtailed by this behavior. Now, why does this behavior happen? I hear television debates that say, oh, enhance the penalty, or you need to educate the masses. No, I don't think it is about penalty. When people are brushing against a woman, they are not thinking I'll end up in jail. And they are not scared of going to jail. So they think they will never get caught. So enhancing penalty doesn't help. Education, I mean, what are you going to do? You are refusing to deal with the problem that this is coming out of a certain repression of biological instinct. So we have got some Victorian approaches to how do we look at those biological instincts. You practice repression. That repression finds some sort of support in the whole sort of celebration of celibacy that our monks have done. But it creates a certain kind of human being in a man, which then tends to behave in a certain fashion, which puts pressure on women. And that is completely uncalled for. We then, when in the professional environment, we again have a Victorian attitude to women. We insist that women must succeed professionally as if they were men. So we put them to the standards of men. We do not allow them to function as women. So they are meant to dress in a particular fashion. They're meant to behave and speak in a particular fashion. It has various other outcomes as well when you require women to operate in that fashion, but it's unfair. You're requiring them to be non-women. And this is again where I sort of looked around to how do you look at it? Think in terms of, and that's why we have these pictures of where women dressed in Victorian clothes. Just visually look at them, they're covered, you can see their faces, you can see their hands. And that's all that you can do. Important thing about Victorian clothing is the idea of a petticoat and a blouse come from Victorian ideas. These are not Indian clothings. Now today, an Indian woman would believe that a petticoat or a blouse are natural to Indian heritage. They are not. Now you look at traditional pictures of Indian women, and a lot of us have read Amarchitra Kathas. You look at the Sita, you look at the Ahalya, you look at the Sati Savitri in the Amarchitra comics, you look at the manner in which they are dressed. You look at the Draupadi, you look at the manner in which they are dressed. If a woman in India comes, I'm not saying that women should be dressed like that today, but the fact is that that is our tradition. And where we have gravitated to is to believing that our women actually, Indian tradition requires women to be dressed in the Victorian ways. And that again puts pressure because women now have to start competing or going out and competing. There is a certain basic aspect of being a woman that they are actually not able to rely on, which they are actually required to suppress. And that to my mind brings down, disempowers women, brings down their level of dignity. There are other elements. And this is not speed of justice really, but this is just how we create the environment. Contempt of court. Today, truth is not a defense. So a judge can take a bribe, and if I say judge takes a bribe, that is not defense. I can still be sent to jail. That needs to change. So truth needs to come back as a defense. Judges, as again seeing themselves as handlers of sovereignty, need to start looking themselves as service providers, because that is what will bring about whether my performance can be reviewed, how do I get appointed, etc. So that comes hand in hand with having to being a service provider. As a service provider, you need to be a specialist. So the days of, I would think, generalist judges are gone. They need to be, maybe there's room for some kinds of generalist judges, but they are special situations and they need special training. It is impossible for a judge who has done landlord-tenant case or employee cases to come and start becoming a company judge. Similarly, it is impossible for somebody who has done criminal cases to suddenly become a tax judge. But that's what happens in a system. The High Courts and the Supreme Court function exactly like that. So you have reactions from these judges who are laying down laws. You can't fault them for, but because your system requires them to be generalists, they are not able to actually respond accurately or appropriately to special situations. There is then the huge angst that many of us have against the sort of the physical appearance of the cultural practices. So to call a judge a lordship, wear a black gown, black coats, all this should sort of possibly go away. I would say the whole distinction between having a category that calls itself senior, again, this comes from the British system, senior advocates, and which are QCs, or Queen Counsel in the UK versus advocates. We would probably be better served if we go to the US where they're just lawyers or they're just counsel. They have the ability to deal directly with clients. In our case, senior advocates should not, but they still end up dealing with many of them. So there are all kinds of sort of malpractices that come in. You create a culture of some form of a VIP in a court situation, and we want to move away from VIP culture. We should actually then move to saying you can't really get designated in one way or the other. They are just lawyers, and what you do in a particular case is relevant, not what you have done in the past. There's then the last point that I have, which is modernizing and freeing the legal profession. But the legal profession itself is also subject to a whole host of restrictions, which then forces it to act in a slightly different fashion. So, for example, we can't, strictly speaking, lawyers in India have the ability to have very limited websites. Now, my experience being an international lawyer was that people will look for your website, and if many law firms don't have websites at all, if you don't have websites, or if you have a lousy website, you are seen to be a fly-by-night operator. Today, if you have to use any service provider, most of us watching the show, you will actually go and Google that person, and you'll want to try and figure out. Now, if you find that that person is not appearing on the internet, your natural reaction is to think that person is fly-by-night. So that's how these restrictions are working on whether you can have partnerships with non-lawyers. Now, the world is grown to multidisciplinary partnerships. So they are accountants, they are company secretaries, they are lawyers, they're all sort of functioning as partners. Whether Indian law firms, whether you can hire foreign lawyers, whether you can actually allow for foreign firms to come in and compete and improve the quality of Indian lawyering. Again, those are all restrictions that exist, which sort of bring down a system. that was the end of my presentation. Thank you all for watching. If any of you have questions, feel free to fire away. Also, feel free to email me on my email address, which is right at the beginning of the first slide. Uh, that's got my email address there.
Enormous caseloads. Why doesn't the government just increase the number of courts and judges India-wide? Wouldn't this be simple and non-controversial? And question number 2 is, why not have the retirement age for judges like any other government employee? This will also create vacant posts and for upcoming job seekers.
So the second one is where is contrary to what I was saying. I don't think the judiciary should be an employment opportunity. The job of the judiciary is to provide justice to the people. So it's not a place where people look for employment. And that's why I say judges should be judges for a lifetime. In terms of just increasing the number of courts and the judges, I think that there are financial challenges and there are technical challenges, in the sense that financial challenges, you need to build the infrastructure which costs money. And I think that's where technology can actually help, because you can spend that amount rather than building physical infrastructure on spending on technology, and you can actually get far greater benefit rather than just increasing the number of judges. The other issue with increasing the number of judges is, how do you find as many highly qualified people that can actually be judges, and how many highly qualified people want to be judges? Because many highly qualified judges, there are salary limitations to what a judge can do. The very good guys tend not to at least want to be lawyers and not judges. So there are some natural hindrances there, but I think an answer to that lies in technology, where you can harness technology and you can make it appear as if there are a lot more judges than they are, and you can process the information or process the cases much faster.
Sir, it was very good session. As a citizen of India and coming from a non-legal background, can you let me know 3 steps which I can do at my individual capacity or at my local friends capacity to strengthen the legal system? Anything related to that? Please guide us, sir. 3 things. Thank you.
So the solution in terms of strengthening the legal system lies in what the state can do, because individuals can't really contribute so much to enhancing the level of justice. I mean, I can give you the philosophical answers of be a nice guy and things like that, do fair things, behave fairly with people, but that's not how you set up a legal system. Now, when I sort of, and it's often occurred to me, I've thought, why is it that people in the US are more prone to be more direct, more honest, with a higher level of integrity, and we guys in India are not? And you will see it happening at traffic signals where they won't violate. You will see it when it comes to contracts. You will see it. That's not to say that there are no violations, but the level of compliance is much higher. And I think the reason is essentially because there is enforcement in the US. There is practically zero enforcement in India. So, there'll be lots of lawyers who will tell a client, if a client comes, I'm in this difficult situation vis-a-vis this contract, what should I do? They'll say, just go and breach it. When it comes to enforcement, we'll see. And as that movie said, tariko pe tarik lagate hue chale jayenge. So really the solution doesn't lie from an individual level, rather than if you take it philosophically, it lies in what the state needs to do to improve the environment. I'm not sure if that answers what you were seeking.
So, hi Anand. My question was really that it's good to see that there are solutions. It looks like a lot of the solutions are very doable. And like you said, a lot of these have been talked of for a while. But how do you see these as actually being implemented? Because, for many years, we're just seeing no progress.
No, you're right. A lot of the things that I just made out in the presentation are known. A lot of them are getting better known. I mean, essentially, it has to come through governance. I can't say that you need to vote one way or the other, because every political establishment that we have kind of is one word variation of the same. So it's more of the same. But essentially, it needs to come from a sense, and hopefully from this government, there's a greater sense that you need to do right by the common guy. You got to be clear is that economic growth cannot happen. You could do a few things in terms of policy measures to open up the economy to make it make things happen. But really, let's say I am this whole enforcement environment. Uh, as somebody that comes from the outside, if I want to, so I come from a non-business manufacturing background. If I want to set up a business, I want to set up a manufacturing facility, it is a nightmare. So there is a glass ceiling that operates on account of the manner in which our system operates. I mean, when I came to being a lawyer, people said, if you're nobody in the law, then what are you doing? Why are you wasting your time with trying to be a lawyer? And so there are these glass ceilings that come into existence, which are extremely strong. And the fact that we have no enforcement accentuates it. I think it is for the government, it is for governance to actually see that these are the problems. When you talk about ease of doing business, when you talk about Make in India is not happening, why are these things not happening? It is happening because you have zilch enforcement. If you do not have proper enforcement, it is impossible. Otherwise, it's law of the jungle. Then you might as well just, which is increasingly, it is gravitating towards that. So people are figuring out different ways to loot money, run away, commit fraud, use arbitrage by breach. So if governments want the economy to grow, if you want the country to be a strong country, there is no way but to fix the plumbing. The fundamentals has to work, because otherwise there are such big gaps in your pipeline that as much as water you might put in the pipeline, which is in terms of any other ideas, it will all go out of the leakages because the basic legal system does not work. And it is increasingly becoming more and more apparent that it does not work.
Very nice session. I learned a lot of things from what you talked about. So I'm not a legal person. I don't know if I have a question, but I just want to say a couple of things. So one, I think in the beginning part of your session, you were talking a lot of things which I believe point in the direction that there has to be a lot more objectivity into the system to provide justice. However, I don't know if that framework would work in a place like India, because here the society by default is very heterogeneous. And for a lot of people, I believe the sense of justice is not in that instance, but it sometimes goes very far back into the history. If not history, I should say at least generations. And I'm not sure if that kind of thing would really work here, even though I think the country boasts and all of us boast of that we are a democracy and all, but just limited to the voting part, because when you see that, some very influential people can actually make the courts open till late or in the middle of the night, but for common people, it's just not possible. I mean, one cannot even dream of. That makes me wonder if objectivity is really going to be, possible in such a system. So I'm not sure what efforts have been made, but keeping that in mind, I don't know what all is possible. But it remains like, as a common person, justice is something which is a very far-fetched idea for quite a few of us. Anyway, that's all.
So Rohit, that's absolutely right. Is that where we have arrived in the manner in which we see our justice? It is excellent in the textbooks. It is pathetic when it comes to practice, and it works for the rich and the powerful. It does not work for the average, and that is what needs to change. Because whatever justice happens, I can't rely on justice that will get out of my karmic goods or somebody else's karmic bags in the next life or his next life. I mean, that may be one way of looking at it, but that is when you are in a helpless situation. I think that's making virtue out of necessity. Is that you have no other option, but you say that iska aage chal ke kuch ho jayega. The reality is, if that should not be a necessity, is that it should not be a system that prioritizes the rich and the wealthy. It must be a system that works well for everybody. And that's kind of what we will need to, if we need to go in that direction, there are some objective benchmarks that we will have to set ourselves by, and we will need to push in those directions. And as I said, if you think that justice is going to be perfection, forget about it. Perfect justice is a mirage. So if you look at dharmic ideas, you will find that there's a debate between different people's dharmas, and it is highly confusing. So if you take that Indian approach that unless I get to perfection, I will not change, then I would imagine that that is a recipe for no change.
I think the PIL system in India has failed miserably. Do you agree? And could measurable, time-bound, real outcomes fix that? The case in point I'm thinking of is waste management, PIL by Almitra Patel, which he won in 1996. But even 25 years later, the outcomes are still terrible.
So, I suggest, you're absolutely right. I mean, my own sense is that PIL systems have not worked, which is why I suggested an alternate. Is that we have a sense of, so what's happening with PILs is that judges sitting, as they say it, in their ivory towers, deliver judgments. They don't know the ground realities. These judgments do not work on the ground, which is why some of the decisions have to be taken by administrators, because administrators and the executive is closer to the ground. It understands ground realities better. It understands what works better. So for somebody sitting in an ivory tower to direct an outcome on the ground level, very often it does not work. And maybe that's the reason why after 25 years something is not working, because somewhere on the ground level it will not work, and it is impossible for a court to micromanage outcomes. But there is also, so having said that court needs to stay out of it and it is the task of the executive, we also have the reality that the executive and administration is also a big failure. So as a common citizen, what do? Do you take up arms, or do you actually need to have some avenue? Today, because there is no other avenue, the courts have used certain constitutional provisions to start delivering those administrative solutions. Many of the solutions are going fairly badly. So what is the alternate? We do need somewhere to go to. It may be the unelected exercising statutory authority by using this process. But what does a common citizen do? So I think the only time you can get rid of some sort of intervention in the nature of PIL completely is where the executive starts delivering at a far greater level, which is where, like the US, you can then rely on class action suits, which are somewhat similar like PIL, they are public interest. And India can gravitate in that direction. But until then, when you want immediate fixes, I think there'll need to be some avenue that is available to the common man, where you can go and knock doors and get some sort of immediate recourse. But that immediate recourse is not one that cannot be tested in law. So, which is what I, as a lawyer, would describe as judicial review, is that there is a court that then looks at whatever action has happened and to look at whether it is constitutionally sustainable or not. And so that, in my mind, is the balance that you would look at when you look at PILs.
Thank you, sir, for this very nice deliberation. And as a non-lawyer, as a layman, it really was very informative. I have got a small question. Our courts are all the time, they are very harsh on police, bureaucracy, politicians, and all other institutions. And that seems like our courts have no accountability at all. Is there any kind of a system? Is there, or anything like that is possible, where the judges should have been given some kind of rating based on maybe the number of cases decided, quality of judgment, and all that? Because we have seen that there had been cases that certain judges are very quick in delivering judgments, and their judgments are very good written. And there had been cases where some court has given a judgment which is totally out of sync with the reality.
So you're right, Sunil, you're right.
Appraisal.
You're right, and which is why in my presentation also I mentioned the need for going in the direction of performance review of judges. It is an essential. So as long as you have a judge that says I'm exercising sovereign power, so I'm like a king, and a king is, or an English king, because an Indian king was always subject to review. An Indian king was also sent out in exile and things like that when he did some wrong. But an European king was immune. That was sovereign immunity. So our court systems have taken that part of sovereign immunity and have, so because we came down from the British system, that's how the English operated. We continue to operate in that fashion, or our courts continue to operate in that fashion. And therefore we say that since I am a sovereign, or I'm exercising sovereign authority, what I do should not be subject to review. And there should be no, so we need constitutional amendment to my mind. You can do it at certain levels, maybe a constitutional amendment, because if you try and do it without a constitutional amendment, it will get challenged in court and it will probably get knocked down by some self-serving judges. So if you do a constitutional amendment, say that judges should become service providers and the quality of the service they deliver should be subject to review. Maybe individual litigants that go to court, maybe they have feedback to offer because the case runs for a certain time. So at different points in time, you can give feedback on how the court is, what is your experience in court. I mean, just like you go to a Decathlon store, they ask you, how was your experience in the store? So you get the right to actually give feedback. You must get the right to give feedback for your experience, not just in governance, but also with regard to court. And that must be factored in when you review the performance of a judge.
Interesting conversation as always. Some potentially polarizing views in there. One which especially caught my attention was, and I'm asking just for a little bit more clarity on this one, was your espousal of celebration of institutional violence in popular cinema. What it led me to wonder was, are you really advocating for a grassroots level democratization, to this extent, where where the judicial system or perhaps even the legislature should pay heed to common sentiments which are so easily roused by media reports being presented in a certain way. I just feel like if one were to play into public sentiment, elitist or not, it's very easy perhaps to manipulate the judicial system, right? So where must the boundaries be drawn with respect to the popular sentiment informing judicial action?
Hi, Sati. So good point. Like I said, it is highly contentious, something like this. But so we need to recognize certain facts and then figure out, at least that's the approach that I take with something like this, recognize certain facts and try and figure out how do you sort of work around it. The recognition of the fact is that by and large, so you take the Punjab militancy case. Almost everybody will tell you that it got sorted out on account of extrajudicial killings. And KPS Gill was a hero for doing that. Now, our sentiment has again been system oriented. So the West is very system oriented because they have a certain approach. Our sentiment is very outcome, as Indians or as Asians, very outcome oriented. So we are not so concerned as the common man. We are not so concerned about what process is followed as long as you can get the last thing right, which is as long as you can deliver justice. So if there's a criminal, as long as justice has been delivered, we are quite okay. Which is where the friction lies, is that the popular sentiment, therefore, and you're right, there is room for misinformation, there is room for people in power to use media to portray innocent people as criminals and therefore get away with the extrajudicial executions. And those are all very, very valid points. But if you look at the basic sentiment where Indians are comfortable with people getting knocked off, so there's huge resentment against Ajmal Kasab getting the long trial that he did. It is quite clear, open and shut case that he needed to be executed. So why put him through that long process? And that's where our sentiment is. Now the question is, in a democratic country, if you call yourself democracy, should an elitist view, and I would not call it Western, I would say that the Indian elite has a certain inclination in these matters, I would say that the fear of this extrajudicial process comes out of, are you going to hit innocents? So the solution must lie not in saying that bar something, but how do you create a system where you can have innocents protected? And maybe the solution might lie in saying cops entitled to do violence, but the burden of proof is on the cop. It is not per se illegal to commit a certain execution, and it's a matter of debate. But as long as you can demonstrate that somebody got what they deserved, as long as you have a good mechanism to do that, this might be a possibility because it has got enormous support in our population. And as a democracy, there is no way that you should look to ignore that. I mean, you do have the ability to say, it should not be a democracy in that case. And people should not enjoy freedoms. And that is another approach. But when you look at the Indian sentiment, the question is, how do you work it? And think of the cops. I mean, think of if you were a cop and there's so much of pressure on you. You're doing investigation. You're required to find, are you going to feed somebody rasgullas to give out the truth? And it won't. And I have known for fierce proponents of human rights to get people beaten up because they believe that they're thieves. Domestics beaten up by the cops. Now, all their human rights goes into the air when it comes to personalization of such situation. And the answer that you get when you talk to lots of people in terms of personalized hypothetical example, they will say, no, you're personalizing it. You're making the issue smaller than what it is. But the reality is that by and large in our population, there is acceptance that as long as you can get the solution right, we don't have a problem with the process. So the mindset that is very process oriented and process driven comes from something that is not fully Indian. I'm not saying that we should do this only because it is Indian, but I'm more outcome oriented than I'm process oriented, and I think that might be one of the dividing lines. But there is need for debate. I'm not saying that this is what I say must happen, but there is need to debate this question.
Namaste, Anandji. My question is that even if the government tries to implement some of the suggestions you have given, such as nullifying Article 142 or something of that sort, the judiciary itself can overturn it, calling it unconstitutional like it did in the NJSC case. So what could possibly be done about that?
See, ultimately, you're absolutely right. But 142 is not one of the basic features of the Constitution. Judicial independence is. So when they look at the NJSC, they can say it transgresses judicial independence, which is one of the basic features of the Constitution under Keshav Nanda Bharati. But 142 is not. We have to remember that 142 is a rare constitutional provision. It probably does not exist in the very few countries, if at all, in whose constitution it exists. But 142 does not. And for those who are not lawyers, 142 of the Constitution is the constitutional provision that allows the court to do whatever it wants to do, regardless of the underlying law, in the interest of justice. That's how it's been interpreted. In the past, it was seen to be a right to create a bridge between two laws. So if one law ends here, another ends here. 142 allows you to create a bridge. But today, 142 is being used to overrule existing statute and existing law, and to be whimsical about how justice is delivered. So you're right, it could come up for test. It is for the system and people who argue in that system to figure out, maybe there is a room to put it in one of those categories that cannot be subject to constitutional review. So those are issues in terms of how do you make that amendment, how do you take away that right, because it is resulting in erosion of the line between executive and judicial.
So thank you so much, sir. It's wonderful having legal representation in the Indic thought field. So I have a few questions, so I'm just going to quickly throw them at you. The first question is your views on Professor Kane's work on the history of Dharma Shastras and his critique that the Constitution gives a false notion among the people that they have rights but no obligations. The second one is representation, especially of minorities, is very essential in any healthy democracy. But the Supreme Court that enforces this seems to have the least amount of representations of especially SC/STs in the last 70 years of our history. Why doesn't the Supreme Court itself take its own interpretations into view? And the third question I want to ask, this is from a lawyer's perspective. After 70 years, why do we still cling on to the black robes and black coat, which have no meaning to our country, to our values, to our system, but to simply state that we still carry on the hierarchy that the British established?
So on the cultural element, the black coats, black robes, the hierarchy, etc., that's the point that I made in my last slide, is that we need to get rid of that. Is that it is okay when we were under British Raj? Probably okay for another 10, 15 years, because we want to cross over to something that is more amenable to the Indian way. I mean, why in the summer of Delhi at 45, 46 degrees should I be wearing a black coat and a black gown on top of it? Doesn't make sense as long as they're nicely attired. So you have uncomfortable people. You have to go and address somebody as my lord. And when you repeatedly, the reality of the world is, when you repeatedly address somebody as my lord, they actually do start believing that they are your lord. And it gives them that impression that they are in the nature of a sovereign. And that needs to be reversed. As I said, one of the things that we need to change is judges need to be more service providers than sovereigns. So you need to deliver justice. Justice is a service that it's an essential service. It's an essential sovereign service that we are entitled to. And culture and this sort of iconography that we adopt in courts does have the ability to sort of skew what we are looking from the court system, which is in terms of justice. So yes, there needs to be that cultural shift. In terms of minority representation in courts, I would say, again, the point that I made is to look at the court system as a justice delivery mechanism rather than an employment opportunity place. Employment opportunities and equality of opportunities available in various places. These guys are meant to do a job. Ideally, I would like the judges to be replaced by artificial intelligence. So no people at all. And that is probably the way the world will go in the next 15, 20, 30, 25 years. So essentially, this is an essential, justice is an essential service that a state must deliver to its people. And how it does it. Now, I do take the point is that to certain minorities and certain sections of society, it does feel like a sense of justice if they see representation in a certain institution. And there is value to saying that. But again, my point is, justice must get delivered. It is not, I mean, the question is, do those minorities, do those underprivileged sections of society, will they have a freer, a more just life if the system worked very quickly, if they got justice very, very quickly? Or are they happier just dealing with iconography? So are you happier just getting representation here or there? And it is, again, I would take the point that it is not one for the other. Both can happen at the same time. Both can happen, they should happen. But the primary purpose, as I say, again, of justice delivery system is to deliver justice and nothing more. Professor Kane's work on Dharma Shastra, I'm not aware of. But I do have, and this is probably, it works well to close with a discussion on Dharma Shastras and how you might work it in the Indian system, is that the Dharma, what is Dharma and what is not, and how does it work, is an idea that has got significantly diluted in the Indian mind. So we don't understand really, I mean, having said that, Arjuna never understood what Dharma was very clearly, because not only did he get an instruction directly from God in the Bhagavad Gita, and though God showed him his universal manifestation, he still did not understand it. And then Krishna had to undergo another round of discussion with him to explain to him. So Arjuna is not an ordinary mortal. Arjuna is a highly superior being, he's a highly spiritual being, incapable of comprehending properly what Dharma is. and therefore keeps asking for explanations again and again. My limited point is, what is dharma, how it works, because dharma is different for different people. What is the idea of dharma? So we look at dharma in a materialistic sense. My own sense is dharma is a set of rules that works towards spiritual enhancement. Today, we live in a material world. Our objective, our end goals are materialistic in nature. They are not spiritual in nature. If you want materialistic outcomes, then probably there are another set of rules that apply. But when you talk about a dharmic society, my sense is that dharmic society is not oriented so much towards material goals. It is oriented more towards spiritual goals. And just what the goals in our societies are very different. So to apply these set of rules in this context may not work as well. At a time when society becomes more spiritually oriented, probably there's greater room to be more dharmic in our law and our implementation. But otherwise, there will always be confusion, because we look at a material world and we apply these dharmic concepts, highly confusing, because everybody's dharma might be different. And how do you get judges that understand each individual's dharma? Because dharma might also change given circumstances. So it is an interesting thought, but I think we just need to dig a lot more deeper into what dharma is, and there needs to be greater socialization of what dharma is.